everyone. My name is Alekhya, Assistant Professor in Cybersecurity Department in Institute of Aeronautical Engineering College. So today we are going to discuss about intellectual property in cyberspace. So first of all, what is cyberspace and what is intellectual property? So cyberspace is nothing but the communication or the interaction for the internet for ourselves. So the interaction between the people and the internet is nothing but the cyberspace. And what is intellectual property? So it can be said that intellectual property is one of the right that has been given to a particular work to the person. So the work that has dedicated by one particular people or one particular organization. So that intellectual property has been given to that person or for the work that has been delivered. So it is nothing but intellectual property in cyberspace. So what is intellectual property in cyberspace? Let us discuss now. So today our contents are intellectual property in cyberspace. So it is all alike but having some variations among them. So what are the different types of intellectual properties in cyberspace? We can say that like first one, copyright, next patent, trademark, trade secret, trade name and domain name. So these are some intellectual properties in cyberspace. So intellectual property. So it is a number of distinct types of creations of the mind like inventions, literary and artistic like works and some symbols, names, images, designs, some ideas, ideologies. So that is coming from the own person or the dedication of some person to particular service or anything. So that these are all comes under intellectual properties. So in this legal word, IP is a generic term. So for IP is nothing but intellectual property. It is a general term for legal entitlements. So that was attached to some certain names, written and recorded media and inventions. So it is nothing but that access, that particular work has been given or some particular work or some service that has been given by the some person, and the access should be done by that particular person or the organization itself, not with any other people. So it is some of the right that has been given to that person. And those who hold these legal entitlements, they may apply various exclusive rights. So they may apply some various exclusive rights. There has been given some anonymous rights. So in relation to the subject, that is subject matter of the intellectual property. So these people has given some certain rights how they can deal with, or if they want to change some modifications or they want to do something about that, only those people have the access to do that. So it is nothing but intellectual property. So here the word intellectual, so which indicates the fact that this term concerns a process of the mind. So it mainly concerns about the process of the mind. And the word property, in its noun form, it implies that the idea of generation is anonymous to the construction of tangible objects. So what is intellectual? So it mainly indicates the fact that concerns a process of the mind, whereas the word is nothing but it implies the idea, generation, and is anonymous to the construction of tangible objects. And consequently, this term is controversial. So law and law enforcement about intellectual property like differs considerably, depends on the jurisdiction. So according to the law enforcement, there will be some difference among them, or there is some controversy that is being on them. And intergovernmental efforts, they are in process to harmonize them through like international treaties. So such as in 1994 World Trade Organization. So it is an agreement on trade related aspects. So it is the trade related aspects of intellectual property rights. So while other treaties may facilitate registration in more than one jurisdiction at a time. So see here, so what is intellectual property means? So when it was started, it was like inter so inter inter intergovernmental efforts. So they are in progress to harmonize them through international treaties. Like in 1994, what happened? So World Trade Organization (WTO). So they have an agreement on trade-related aspects of intellectual property rights. So agreement on like TRIPS, it is nothing but TRIPS, trade-related aspects of intellectual property rights. So whereas treaties may facilitate registration in more than one jurisdiction at a time. So there has been disagreements over medical and software patents. So there is some conflictions among them between the medical and software patents. So the rigorous of copyright enforcement that has so far prevented consensus on a cohesion international system. So the important point is that these particular intellectual property laws, they confer a bundle of exclusive ideas in relation to the particular form or matter in which ideas or information were expressed or manifested, and not in relationship to the ideas or concepts themselves. So the ideas or the concepts that were built by that particular people, there has been given some rights. So it is like the copyrights, the patents or anything. So it is being extracted from the intellectual property rights. And the term intellectual property. So what is the term intellectual property? So it denotes the specific legal rights to assign to authors. So who has invented, who has written. So those people having some legal rights, and other IP holders who may exercise those rights. So however, the term do not donate the intellectual work itself. So here the intellectual property is nothing but some legal rights that has been given to the author or the inventor or other IP holders who have the exercise of those rights. And here ethics. So ethics is a branch of philosophy that deals with what is considered to be right and what is considered to be wrong. And here computer ethics is much important when it comes to ethical hacking or ethical doings. So considering its ramifications and impacts on the related domains. So for this we are having some figure like ethics in computing. So see here, so what are the ethics that has to be followed or what are the things that has been done. So in intellectual properties, so there can be electronic copyright, software piracy, patent and copyrights. Like that they are having some law enforcements. And in commerce, so we are having law fraud, taxation, free trade, gambling, anti-competitive practices. All this will be in commons. And when coming to basics in ethics in computing, so what are the basics? It has to be principles, whistleblowing and codes of ethics. And when social justice issues, so if there is any social justice issues, so through the ethics in computing, so there might be downside of computer age, workplace issues, equity of access, like that there will be some ethics. And when it comes to risks, computer models and licenses, network security, software reliability and safety, there will be it will be there in risks. And when coming to piracy, so piracy in anonymity, so it will be speech issues and privacy both will be adjusted by the anonymous. So here we are having email privacy on the website, encryption, spamming, database privacy, like that. And speech issues, so when it comes to speech issues, so chain letters, free speech, etiquette, like anonymity. So all this will be considered. So computer abuse. So worms, viruses, Trojan horses, hacking, all this will be there in computer abuse. So these are all the ethics in computing in different domains. So these are the domains. When coming to commerce, there will be some ethics that can be done through that. So when it comes to social justice issues, risks, privacies, speech issues, computer abuse. So all these are some type of domains where it will be cleared by using ethics in computing. So these are some ethical thinking details, like ethical tools. That we can say that ethical tools. And here, ethics and morality. So they both have a relationship with human behavior and attitude. So ethics has to be followed and morality has to be followed. So the morals they should be the equal importance that has been given to both the ethics and the morals. So according to the human behavior and attitude. So attempting to change people's behavior or attitudes, there seems to be some challenge to the ethical minefield. And if some communications paradigm has multiple roles and many people are involved. So salespersons, political activities, socialists, etc. So we are having so many types of people over the internet. So here, we may not be believed that the persuader has our best interest in mind. So we should not having best interest in mind. So as it is the case, we all new technologies, ethical considerations, the trial behind technical capabilities. So we may feel under our own pressure or social pressure to take a particular action. So this is because our lives are now hopelessly tangled with information and communication technology and interrelated agencies. So whereas all our details will be considered in the internet, or the things will be easily extracted from the our personal details can be extracted from the internet. So this is where our lives are very hopeless according to the ICT, information and communication technology interrelated agencies. And next one, intellectual property in the cyberspace. So what it actually mean? So here information is fluid in nature. So we are having huge amount of information. So in the modern world, it resides on diverse networks. So for different types of networks, we are having different types of models, and in this modern world, we are having so much amount of information. So this has caused some confusion about how intellectual property rights apply to fields in electronic form. So how we can apply the intellectual property rights for our work or services through the internet. So in the long back, when the world of network users was relatively small, so an emphasis of free exchange of information and a common understanding of intellectual property created, and most conflicts over the use of information has been done. But today, networks has grown very large. So at that time, there will be some small networks and the information will be small, and the exchange of information is also easy, and the having IP, like intellectual property rights, is also easy for the people. But according to now, the networks has grown very large. So whereas the information extracting is difficult, so the networks identification is difficult. So like that, there are far too many users, and networks now attract a much broader range of people. So when it compared to the past, so because of the growth within the users or the networks, so it is very difficult for the people to extract the data. So broader range of people as compared in the past, when only university and government networks were active. So in such scenario, what happened? Clarification about the electronic files become essential. So clarification. So who has done the particular work? Who has done this particular work? Who this trademark belongs to? Who this copyright belongs to? So everything that has to be clear. That has to give us some clarification about that. So electronic files can be copied and distributed easily. So with a small click, the files can be extracted, they can be altered, they can be compromised, anything can be done with these particular electronic files. So the nature of some electronic information can create problems within existing copyright law. So either the law does not address the vulnerabilities, vulnerabilities of the electronic information, or the law is too easily subverted of ease with which files can be copied and transferred. So similar problems has arisen with photocopy machines, video cassette records, and tape records. So same thing. So based on these photocopy machines, video cassette records and tape records, they are very easy to extract the information. So the information can be distributed easily, they can be extracted easily, they can be deleted easily. So further, it becomes more matter because more complex when other countries may have other kinds of copyright laws. So we are having some, so in our country we are having some particular types of copyrights, whereas other country will have some other particular types of copyrights. So like that, so we have to distinguish between that and we have to follow our rules. So IP, intellectual property laws that are meant to protect various forms of subject that matters as mentioned below. So however, we are having these can be a degree of overlaps. So based on the law enforcement, based on the type of service we are giving, that can be given. So whereas if it's globally through a network may not have the same protections in other places. So for that we have to follow the some particular things. So let us see some types of intellectual property rights. So in that first one copyright. First one copyright, patents, trademarks, what is trade secret, trade name, so domain name. So let us take some look for each of these IP instances. So what are the scenarios based on this type of intellectual property rights? So first one copyright. So what is copyright? So it is the legal concept meant to give exclusive rights to the creator of original work. So it is the copyright that has been given to the original work of a particular person. So usually such rights do not last perpetually. So they exist only for a limited time. So copyrights will be only for the limited time. Only for the limited time. So in its most general form, copyright is literally the right to copy. So the right to copy is nothing but only that particular person has the right to copy that particular concept or some particular service, and they can change some, they can give some modifications further. So only have that particular person have the right to copy. And however, it is the best owns upon the copyright holder the right to the credited for the work to determine who can perform it or adopt it for other forms. So to benefit financially from the work and other related rights. So they can be benefit financially. Benefit financially. And next one, copyright is one of the form of intellectual property where it is different from patents, trademarks and trade secrets. They are completely different from some patents, trademarks and some trade secrets. And this copyright applies to a particular expression of an idea or information which is substantial and self-contained in a fixed form. So what is a copyright? So it is a particular expression of idea or some information. It is an idea or information So here, note that we are having the copyright symbol like this. So it is a circle. So it is a C within the circle. So it has been given some legally recognized symbol as a symbol of copyright. So it is the symbol of copyright. And next one, patent. Next one, patent. A patent is thus a set of exclusive rights granted by a state to an inventor or his assignee for a fixed period of time in exchange for a disclosure or an invention. So what it is the disclosure or an invention. So what is patent? So it is the set of rules that has been granted by a state or an inventor or his or her assignee for a fixed it will be given for some fixed period of time. And it within the exchange of a disclosure or an invention. So they can exchange the disclosure or an invention within that particular fixed period of time. So through law or contractual obligation, exclusive rights can be established. So based on the contractual obligation and the exclusive rights, the exclusive rights can be established. But the scope of enforceability, they will be depend on the extent to which others are bound by the instrument established by the exclusive right. So it is based on the bounds by the instrument. And next one, thus in this case of contractual rights, only persons that are parties to a contract will be affected by the exclusively. Only with the parties with the contract to a contract, those will be affected exclusively, and depending on the country of legislation. So based on the country of legislation, the law enforcement within the country, the procedure for granting patents, the requirements placed on the patentee, and the extent of exclusive rights may vary widely. So it may differ from country to country. So here the legal proceedings would be according to prevailing laws in those countries and international agreements. So the law proceedings will be how it will be? It will be according to the prevailing laws. So the present laws within the country or some other international agreements based on those agreements. And what is patent really? So patent is a term that usually refers to a privilege, that is a right granted to one who invents or discovers a new method or a useful process. So it will be a machine, article of manufacture or composition of matter, or any new and useful important theory like thereof. So what is a patent? So it is a right granted to a person who invents. So who invents or discovers a new method, some new method or new process or some article or composition or some machine for easy process of any particular work or service. So the right that has been given to these things is nothing but a patent. So software patents involves the following issues. So we are having the software patents. We used to have software patents. So where we are having some important issues where whether the software is patentable and whether software can be considered as piece of invention, whether software patents encourage or discourage innovation. So these are the some main important issues that will be in software patents. Next one, trademarks. So trademarks are nothing but symbols. So they are the symbols that will be given to the business to identify their goods and services. So government registration of the trademark confers exclusive legal right to its use. So based on that particular trademark symbols only, the services or goods of that particular business can be identified. So trademarks are very important for the businesses. Based on the trademark only the business people can be identified. That particular business is being held. So like that it will be identified. So it gives exclusive rights to use trademarks on goods and services that was registered to that sign, and to take legal action to prevent anyone from using trademark without consent. So if there is any person who is using some particular registered trademark symbol with his or her business, so there will be some legal action that will be taken. And next one, thus a trademark is a distinctive sign. So it is a very unique sign or indication of some kind of that is used in individual business organizations or any other legal entities. So to uniquely identify the source of its product or services to consumers. So it is for mainly the customers to identify their particular product or the service, and to distinguish its product or services from those other entities. So there might be so many shops which is having same product. So same product, but based on the symbols or based on the trademarks for particular so we are having some cloth store of two shops having side by side. So based on the symbols or based on the trademarks only we can identify particular brand. Based on that brand we can go to that particular shops. So these are the differences for identifying trademarks. So it is mainly the ownership of the patent. So the ownership of the patent. The ownership of the patent is also a point to note. So in most countries, patent application can be made by both natural persons or corporate entities. So one or more entities then become the owners of the patent. So almost always it becomes mandatory that the inventor or the inventors be named, and an invention can be indication can be given on a public record as to how the owner or the owners acquired their rights to the invention from the inventor or inventors. So based on the rights to the invention for the inventor or the inventions, the patents can be given. And next one, trade secret. So it is very much different from these above intellectual property types. So this trade secret is nothing but a formula or a practice or a process or a design or an instrument or a pattern or a complication of information used by the business to obtain an advantage or compete over competitors or consumers or customers, we can say. So it is a trademark is nothing but some formula, we can say. Some milk powders will have some formula, or some so we can say some businesses will have, or some so we are having some cloth stores where we have so many designs. It is nothing, it is their secret, design secret, or their some instruments, some patterns of cloth, some services, or compilation of information, some exchange of information used in the business. They mainly used for financial profit. So it is very advantage over to take the advantage over competitors or consumers, so customers. So it is nothing but a trade secret that cannot be revealed to the other people. So in some jurisdictions, such secrets are referred as confidential information. So confidential information is not only the some credit card details or the bank details or the financial information within the organization. So it is also the trade secret. Trade secret is also considered as one of the important confidential information within the organization. So an organization, they can protect its confidential information through non-complete, non-disclosure contract with its employees. So they can be protect their confidential information through the non-compete, non-disclosure contracts with its employees. So within the constraints of employment law, including only restraint that is reasonable in geographic and time scope. And here, the law for protection of confidential information effectively allows a perpetual monopoly in secret information. So only one particular organization has to know that secret. So it does not expire as expire as a patent would. So patent can be expired at some point of time. So whereas this trade secret cannot be like that. And the lack of formal protection, however, means that third party is not prevented from independently duplicating and using the secret information once it is discovered. So it is trade secret. And when sanction is provided for such type of information, it is to protect it from public disclosure, and it is viewed as an important legal aspect whereby a society protects its overall economic strength. Although interpretations may be the interpretations may be different, there are mainly three factors common to such definitions. So a trade secret is a type of information that is not generally known to the relevant portion of the public. So that will not be completely revealed to the public. Only some portion can be revealed, not complete. How the process will be, what are the ingredients? So if there is any milk powder, so what are the ingredients that will be given, that will be mentioned within the bag. So some portion only mentioned with the details, not complete portion. So how the process will be, how they are doing, with how much heat they are keeping all the ingredients. So those details that will not be given. So it is like only generally known to the relevant portion of the public. Only some part will be given, some part they will not relieve. So it provides some sort of economic benefit to its holders. So they will be mainly for the economic benefit. And it is the subject of reasonable effort to maintain its secrecy. So if the secret is relieved to the other third person or the third party, he may use that particular secret and he can grow before him or her. And here the trade secrets are not protected by law in same manner as trademarks or patents. So they cannot be protected by the law. So probably, one of the most significant difference is trade secret is protected without disclosure of the secret. They can be protected without disclosure of the secret. And next one, trade name. So trade name, a trade name is known as a trading name or a business name, we can say. So it is the name that business trades under for commercial purposes. So that based on the name also that can be identified. So its registered legal name is used for contracts and other formal situations. And here a trade name is also known as assumed name or a corporate name. So for example, consider this. Pharmaceuticals have these trade names like aspirin and often dissimilar to its chemical names so this is one of the ingredient that will be used in that aspirin medicine. So it's like acetylsalicylic acid. And here there is a difference between the trade name and the trademark. So what it is? So there are also situations where both may be same. So as mentioned before, trade name is the name under which the organization carries its business. So a trade name identifies the business itself, whereas a trademark identifies goods or services or products. So it is the trademark that identifies the business itself, whereas the trademark, what it will identify the goods and services or products. So in such circumstances, though it may be possible that a trade name can also be served as a trademark. So the trade name can also be we can carry out as a trademark. So if it meets the necessities of a trademark. And last one, domain name. So every computer on the internet has a unique identification number. So every computer, every equipment having some unique identification number. So which is nothing but internet protocol address. So we can say IP address in our normal language. So computers use this IP address to find internet site. So internet protocol address, it will be having some 32-bit numeric address. So as such, they are too long and not too easy for people to remember. So in order for human memories to more easily recall internet protocol address, they are mapped by the domain name system DNS to domain names that contain words. So the registration of the domain name, it does not in itself confer proprietary rights. So they'll try to use the particular name. So this associated with the domain name is it is a phenomenon like cyber squatting. So the domain this particular IP address that will be integrated with the domain name, it is nothing but the cyber squatting. So in US there are federal laws like anti cyber squatting, and here according to Consumer Protection Act, according to this law, cyber squatting means registering, trafficking in or using a domain name with bad faith intent to profit from goodwill of a trademark belonging to someone else. So here, based on the domain name, also cyber attacks are happening. So it may be using the particular domain name to their businesses, or they are using for some bad intentions. They are trafficking like cyber squat, spywaring on that particular organization based on the domain name. Trademark, it also belongs to someone else. So here cyber squatter, what they cyber squatter then makes a high price offer to sell some domain to the individual or organization who owns a trademark content within the name. So they'll manufacture that particular domain name, and they'll try to sell that particular organization to other persons. So based on the trademark content within the name, so for higher price they'll try to sell. So it is also one of the cyber attack. So which is domain name, based on the domain names also. So the registration of domain names is also important. So it is a integration it is like associating with the domain name. It is nothing but cyber squatting. So these are the types of intellectual property rights within the cyberspace. So these are the references that was taken. So what are the types we are having in our intellectual property rights? First one, copyrights, where the expiry time will be very less. So it is having some expiry time. Patents, trademarks, trade secrets, where it will not have any expiry time. So any time we can use that particular trade secrets, trade names, domain names. So these are some intellectual property instances, the situations we have discussed. Thank you.
Like, share and subscribe. Hit the bell icon for more updates.